Okay, picture this, because honestly, it happens way more than you'd probably think. You've just landed what seems like the perfect role.
Hmm.
The salary looks great, the contract, it's right there in your inbox. You're feeling pretty confident, right? So confident you actually resign from your current safe job straight away.
Yeah, you jump the gun maybe a little.
Maybe. And then you send just one, polite email, maybe asking about the start date or clarifying one tiny little clause in the contract.
Something standard.
Exactly. But the next email you get back, it's not a clarification, it's a retraction. Boom. Offer withdrawn instantly.
Ouch.
And here's where it gets really, really interesting. In that gap, that surprisingly dangerous gap between getting the formal job offer and your actual first day, what legal rights do you actually have?
Not many, it turns out.
Welcome to the deep dive. Today we're digging into some recent Australian court and commission rulings all about adverse action claims and these withdrawn job offers. Our mission, really, is to figure out where that crucial legal line is drawn. The moment before employment officially kicks in, the moment that basically changes everything about your workplace rights.
And it's so important because adverse action is usually, well, it's often your main defense in these kinds of situations.
Right.
So adverse action, right, that's basically when an employer does something detrimental, like sacking you or disadvantaging you somehow because you used a workplace, right, you're entitled to.
Or because of who you are, like a protected attribute.
Exactly, like having a disability or maybe being a union member. But the courts have had to get really specific lately, asking if you haven't actually started work yet, what rights or entitlements have you really established?
Okay.
And the two cases we're looking at today, they really highlight just how big that legal gap can be when you're just a prospective employee. It's quite a vulnerable position.
Okay, let's unpack this then. Our first big ruling, this one kind of centered on negotiation, right? It's Australasian Meat Industry Employees Union v. Meat Inspectors PEVI Ltd.
That's the one, the meat inspector case.
So the background, Stephen Light, he's a Victorian meat inspector, and he was facing redundancy because his job was getting outsourced.
Right. Standard stuff, unfortunately.
The new contractor, Meat Inspectors Plea Ltd., they offer him a job, he gets the contract, and like anyone would, really, he sends it off to his union to have a look. Good practice.
Absolutely. You'd want someone to check the fine print.
So the union, they look it over and spot, I think, 5 things that were different from his old contract. Stuff about mobility, a 6-month probation period, leave.
Yeah, a few key terms. Mobility, probation, personal leaves, the enterprise agreement expiry, and the award it sat under. Things you definitely want clarity on.
For sure. So the union, acting as his representative, reaches out to the company, and they specifically make what they call inquiries about those 5 points.
Just asking questions, essentially.
Seems reasonable, and the company actually responded pretty quickly. They even made some concessions. They agreed to remove this probation period, allowed Mr. Leda to initial a change on the travel clause.
So some back and forth, some negotiation happening.
Yes. But crucially, in that same email, the company points out that since he hadn't signed anything yet, he was, quote, not considered an employee.
Laying down the marker there.
Exactly. And this is where it gets risky. After the company sends that email with the concessions and that statement, neither Mr. Light nor his union replied.
Silence.
Total silence for 5 weeks.
5 weeks. Wow. Okay.
Then the company formally withdrew the job offer.
Okay, so the union then files an adverse action claim.
They did. They argued Mr. Late was just exercising a protected right, by asking about his employment terms and also engaging in industrial activity by having the union represent him.
Makes sense on the surface. They'd likely point to the part of the Fair Work Act, Section 3413,
Okay.
that sort of deems prospective employees to have some rights.
Right. But the Federal Circuit and Family Court, they dismissed the claim completely.
Okay, so why? What was the court's reasoning?
This is fascinating. The court drew a really sharp line. They said the union made inquiries basically just seeking info, maybe negotiating, not complaints.
Inquiries versus complaints. What's the legal difference there?
Well, a complaint, according to the court, implies you're expressing discontent about something you're already entitled to, seeking some kind of fix or redress based on an existing right.
Okay.
But an inquiry in this context was seen as just asking for information about terms that weren't finalized yet.
So because the contract wasn't signed, there was no established legal baseline, no entitlement to complain about.
That's exactly it. The court called it the entitlement gap. They ruled that for a workplace right to be protected under adverse action laws, its source must be established.
meaning it has to come from somewhere concrete, like a law, an award, or, crucially, a signed contract.
Precisely. Since Mr. Lade hadn't signed, those terms were just proposals on the table, still being negotiated. They weren't entitlements he actually held yet.
So asking questions about them wasn't seen as exercising an established right. It was just negotiation.
Yeah. Which seems, I don't know, a bit tough. I mean, isn't it just normal due diligence to ask questions before you sign a contract?
It absolutely is normal practice. And that's
Yeah.
the practical difficulty, isn't it? But legally, the court focused purely on whether a right, sourced in law or contract, was being exercised. Here, they found it wasn't.
And what about the 5-week silence? Did that play a part?
Oh, definitely. The court also accepted the company's argument on that. They said the withdrawal wasn't because of the union inquiries, but because of the delay.
Ah.
They had an operational need to fill a role urgently, and waiting 5 weeks with no response, well, the court found that was a valid, non-discriminatory reason to withdraw the offer. The delay broke the connection to the inquiries.
Okay, so that first case, it really highlights the risk of questioning terms before you've locked anything down.
Exactly. Negotiation itself isn't a protected right in this specific adverse action sense, unless it's grounded in an existing entitlement.
Right. Now, let's shift gears to an arguably even more, well, maybe harrowing situation. What happens if you do accept the offer? You resign from your old job. You even disclose a protected attribute, but you still haven't physically started work.
This is the Highness v. Commonwealth case involving the NDIA.
That's the one. So Mr. Highness gets a formal job offer from the National Disability Insurance Agency. He does everything right, resigns from his current job, completes all the onboarding tasks online.
Taking all the boxes.
Yeah, he even confirms his engagement pursuant to the Public Service Act. Sounds pretty official.
It really does. Sounds like he's in.
So then, having done all that, he contacts the NDIA's Disability Liaison Officer. He discloses he has a disability and also some care and responsibilities, and he requests some workplace adjustments before he starts.
Okay, using the broader channels, disclosing a protected attribute, asking for reasonable adjustments, seems standard procedure.
You'd think so. But just a few days later, boom, the NDIA withdraws the offer.
Withdraws it. After he confirmed engagement, what reason did they give?
Their official reason was about his alleged persistent phone calls and some supposed negative comments he made. They basically said he couldn't satisfy the conditions of engagement.
Right. But Mr. Highness's argument was different.
Totally different. He argued the real reason was because he'd disclosed his disability, a protected attribute. He felt this was clearly adverse action, that he'd effectively been dismissed unlawfully.
And he felt he was an employee at that point, understandably.
It's just astonishing, isn't it? He resigned, did all the paperwork, confirmed engagement under an act of parliament. How could he not be considered an employee with protections?
This is where it gets really technical and frankly quite brutal legally. It all came down to the nature of the offer itself.
How so?
The key question for the Fair Work Commission was, had Mr. Highness actually commenced employment? Was he an employee who could be dismissed?
And the answer was?
The answer was no. The commission found that the job offer, even though accepted and confirmed in some ways, was still conditional.
Conditional on what? Pre-employment checks?
Exactly. It was contingent on things like pre-employment checks being fully completed to the employer's satisfaction, and crucially, the offer explicitly stated it could be withdrawn before he actually commenced work on day one.
Ah, the fine print.
Always the fine print.
Yeah.
Because that condition hadn't been fully met, the commencement hadn't happened. The employment relationship hadn't technically clicked into existence yet.
So even confirming engagement wasn't enough.
Apparently not enough to override the conditional nature of the offer before commencement. The commission essentially said, look, an employment relationship didn't exist yet, therefore, it cannot be terminated. You can't be dismissed from a job you haven't legally started.
Wow. So his belief that he'd done everything asked, his resignation from his old job, none of that mattered legally.
The commission acknowledged his perspective, said his view was noted, but ultimately it was not enough to create the employment relationship needed for a dismissal claim under the Fair Work Act. Harsh, but that was the ruling.
Okay. So pulling these two cases together, what does this actually mean for you, the person listening who might be in this situation, that tricky pre-employment phase?
Well, it means your rights before you actually start work are extremely narrow. Much narrower than most people probably assume.
Right. So lesson 1, maybe from the meat inspector case, be really careful about negotiating terms before you sign.
Yeah. Questioning things is normal, but unless your query is tied to a clear existing legal right, you already possess like something in an award that definitely applies. You might just be seen as negotiating.
And that negotiation itself isn't protected from the offer being withdrawn for other reasons, like delay or just the employer changing their mind.
Pretty much. Adverse action protection needs that hook, that established right or attribute. Just bargaining generally doesn't seem to cut it based on that ruling.
Yes, and lesson 2 from the NDIA case.
That's about the conditional offer. Even if you formally accept, even if you resign from your old job, if that new offer has conditions attached like subject to pre-employment checks or commencement date, then the employment relationship probably hasn't started yet.
Which means you're not protected against dismissal or adverse action in the same way an actual employee is.
Yeah.
Even if the reason seems discriminatory.
That seems to be the implication. Until you walk through the door on day one and those conditions are fully met, you're in this kind of legal limbo, a very vulnerable zone.
It's incredibly complex, isn't it? Knowing whether your question is an inquiry or a complaint, knowing exactly when an offer stops being conditional.
It really is.
Yeah.
And getting it wrong can have massive consequences, like losing both your old job and the new offer. This is why, honestly, if you find yourself in this situation and offer withdrawn, maybe feeling like it was unfair or discriminatory, getting specialized advice quickly is critical.
Yeah, we saw in the background material that people often turn to organizations like Australian Workplace Discrimination Representatives, AWDR.
That's right. There are specialist workplace relations representatives, not lawyers necessarily, but experts who really understand the fair work system inside out.
And they help people specifically with these kinds of disputes, general protections, adverse action claims.
Exactly. They know the system, they know the arguments, they know how to handle mediation and negotiation within the commission framework. They help figure out if, say, a withdrawal was genuinely operational, or if there might have been discrimination involved, or if a redundancy wasn't genuine.
So they fight for clients on these issues like unfair dismissal, adverse action.
Yes, they help navigate that whole complex process because they understand precisely where that legal line, the one between prospective and actual employee, gets drawn in practice. And timing is often crucial in lodging claims.
That specialized knowledge sounds absolutely vital here because, as we've seen today, it's not really about the offer, is it? It's about the commencement date and the finality of those contract terms.
That's the nub of it. The courts seem to be drawing a pretty clear, sharp line that protects the employer's flexibility right up until the moment that employment relationship formally begins.
Okay, so let's leave our listeners with a final thought to chew on. Given how narrow these rights are interpreted before you start work, if you get a conditional job offer and you genuinely need to negotiate something important, or perhaps you need to disclose a protected attribute like Mr. Highness did, what steps should you be thinking about strategically to protect yourself as much as possible before you take that irreversible step of resigning from your current secure, protected job? Something to really consider before handing in that notice.